South Carolina gives landlords broad freedom to set and raise rent, consistent with the state's overall landlord-friendly approach to property regulation. The governing law is the South Carolina Residential Landlord and Tenant Act, found in South Carolina Code Title 27, Chapter 40. And while it establishes important procedural requirements for the landlord-tenant relationship, it does not restrict the amount a landlord can charge for rent. South Carolina does not have rent control or rent stabilization of any kind. There is no state statute that caps rent increases, limits the frequency of increases, or requires landlords to obtain approval before raising rent. South Carolina's legislative history shows no serious movement toward rent control, and the state's political and regulatory environment strongly favors property rights and market-based pricing. South Carolina has not enacted a specific preemption statute prohibiting local rent control, but no municipality in the state has enacted or seriously considered local rent restrictions either. Charleston, Columbia, Greenville, Myrtle Beach, and every other South Carolina city operate under the same market-based framework. Given the state's political climate, local rent control is extremely unlikely in the foreseeable future. For month-to-month tenancies, the landlord must provide advance written notice before a rent increase takes effect. South Carolina requires at least 30 days written notice before the end of the rental period for changes to the terms of a month-to-month tenancy. So, if rent is due on the 1st and you want the increase to take effect on May 1st, you need to deliver notice by April 1st at the latest. The notice should be in writing, should clearly state the current rent, the new rent amount, and the effective date of the increase. South Carolina doesn't prescribe a specific statutory form for rent increase notices, but clarity and documentation are essential. Deliver the notice by a method that creates a verifiable record. Personal delivery with a signed acknowledgement, certified mail, or another documented method. For fixed-term leases, the rent is locked in for the duration of the lease term. The landlord cannot raise the rent during a fixed-term lease unless the lease itself contains a provision allowing midterm increases, such as an escalation clause, a provision tied to property tax changes, or a clause linked to CPI adjustments. Without such a provision, the landlord must wait until the lease expires and negotiate the new rent as part of a renewal or new lease agreement. When a fixed-term lease approaches expiration, the landlord should communicate the proposed new rent as early as possible. South Carolina doesn't prescribe a specific notice period for rent increases at lease renewal, because the increase is part of a new contractual arrangement, but giving the tenant adequate time to evaluate the new terms reduces friction and maintains the relationship. If the tenant doesn't agree to the new rate, the lease expires at the end of its term. If the tenant stays and the landlord accepts rent, the tenancy converts to a month-to-month arrangement subject to the 30-day notice requirement for future changes. For week-to-week tenancies, the notice period for rent changes is 7 days, matching the one rental period standard. Now let's cover the restrictions that apply even without rent control. Rent increases cannot be retaliatory. South Carolina has a specific anti-retaliation provision under Section 2740-590 that prohibits landlords from taking adverse action, including raising rent, in retaliation for a tenant exercising their legal rights. Protected activities include making a good faith complaint about habitability to the landlord or a government agency, filing a complaint about a code violation, exercising any right under the Residential Landlord and Tenant Act, and participating in a tenants organization. South Carolina's anti-retaliation statute provides that if a landlord takes adverse action within a specified period after the tenant's protected activity, the tenant can raise retaliation as a defense in any subsequent proceedings. While the statute doesn't create as explicit a presumption period as some states, courts evaluate the timing and circumstances carefully. A rent increase shortly after a tenant files a complaint is going to face judicial scrutiny, and the landlord will need to demonstrate that the increase was driven by legitimate business factors. The consequences of a retaliatory rent increase in South Carolina can include liability for actual damages and attorney's fees. More practically, a finding of retaliation undermines the landlord's credibility in any related legal proceedings and can complicate future eviction actions against the same tenant. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and the South Carolina Fair Housing Law, found in South Carolina Code Title 31, Chapter 21, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, disability, or familial status. The South Carolina Human Affairs Commission investigates fair housing complaints and can take enforcement action including ordering damages, injunctive relief, and civil penalties. A discriminatory rent increase doesn't require proof that the landlord explicitly stated a discriminatory motive. Circumstantial evidence, such as raising rent for all units occupied by families with children while keeping rent stable for units occupied by adults without children, can support a discrimination claim. The pattern of conduct, combined with the timing and magnitude of the increase, creates the evidentiary basis for a complaint. The best protection is consistency. Apply the same criteria for rent increases across all comparable units. Document the market data, operating cost changes, and property improvements that support each increase. Keep records showing that increases are applied uniformly based on legitimate business factors, not tenant characteristics. South Carolina also has consumer protection principles under the South Carolina Unfair Trade Practices Act that could theoretically apply to egregious landlord conduct involving rent increases. If a landlord uses deception or fraud in connection with a rent increase, for example, fabricating cost increases or making false representations about the reason for the increase, the tenant might have a claim under consumer protection law. While this is not a common basis for challenging rent increases, it provides an additional boundary against truly abusive conduct. From a practical standpoint, South Carolina's rental market is diverse and regional. Charleston has one of the most dynamic rental markets in the Southeast, driven by tourism, the military presence at Joint Base Charleston, the Port of Charleston, and a growing technology and healthcare sector. Charleston's historic peninsula and surrounding areas, including Mount Pleasant, North Charleston, and Summerville, have seen significant rent growth in recent years, and landlords in this market typically have strong pricing power. However, Charleston's market also has seasonal dynamics. The tourist season brings increased demand for short-term rentals, and some landlords convert units between long-term and short-term use depending on the season. Landlords considering this strategy should understand the local regulations around short-term rentals, as Charleston has enacted specific rules governing this market. Columbia, the state capital and home to the University of South Carolina, has a rental market driven by state government, the university, and Fort Jackson, one of the largest military training installations in the country. Student housing near USC follows its own cycle, with rent adjustments at the beginning of each academic year. The broader Columbia market is more affordable than Charleston and offers moderate pricing power for landlords. Greenville and the upstate region have experienced remarkable economic growth driven by advanced manufacturing, including BMW's major facility, healthcare, and a diversifying economy. Greenville's rental market has tightened, and landlords have been able to implement meaningful increases. The city's revitalized downtown has been particularly strong for rental demand. Myrtle Beach and the Grand Strand have a tourism-driven economy that creates unique rental dynamics. Year-round rental demand is supplemented by seasonal workers during the peak tourist season, and the market for both long-term and seasonal rentals has been active. Landlords in the Myrtle Beach area should understand the difference between year-round residential tenancies, which are governed by the Residential Landlord and Tenant Act, and short-term vacation rentals, which may be subject to different regulations. Military communities, particularly around Joint Base Charleston, Fort Jackson, Shaw Air Force Base, and the Marine Corps facilities at Parris Island and Beaufort, have rental markets significantly influenced by BAH rates. Service members' housing budgets are tied to their basic allowance for housing, which is adjusted annually. Landlords near military installations should monitor BAH rate changes and factor them into their pricing strategies. One best practice for South Carolina landlords: build your rent increase strategy into the lease from the beginning. Include clear language about how rent adjustments will be handled at renewal, what notice will be provided, and what factors will be considered. Some landlords include a provision stating that the landlord will notify the tenant of the renewal rent at least 60 days before the lease expires. This gives both parties time to plan and sets expectations from day one. Another best practice: consider the cost of turnover when evaluating rent increases. In South Carolina, the cost of turning over a unit, including vacancy time, cleaning, repairs, marketing, and the risk of a less reliable replacement tenant, can easily exceed 1 to 2 months' rent. A moderate increase that retains a good tenant is almost always more profitable than a large increase that causes the tenant to leave. This is especially true in markets outside of Charleston and Greenville, where rental demand may not be strong enough to fill a vacancy quickly. For South Carolina landlords who own properties in coastal areas, hurricane season creates a practical consideration for rent increase timing. Major storms can disrupt the rental market, cause property damage, and temporarily affect demand. Landlords in hurricane-prone areas should factor potential storm disruptions into their financial planning and consider building sufficient reserves to cover periods when rental income may be interrupted. South Carolina requires landlords to return the security deposit within 30 days of the tenant vacating. While this doesn't directly regulate rent increases, landlords should be aware that a rent increase does not automatically entitle them to collect additional security deposit from an existing tenant unless the lease or a new agreement provides for it. For the complete guide to South Carolina rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Landlord Tenant Law series.